Why they have to go. That's what it's. It is the procedure. That's what I got. That's why we keep going back to this meeting. Well, yeah. Spend enough time up there. Yeah, we sort of did it.
Okay, looks like everybody's here that we're expecting. Is there anything we need to discuss before going on the record? Yes, sir.
My name is Steve Ambrose.
Okay, I'm familiar with your name, and I think maybe even met you at some point before. So.
Well, be careful, because there's a very famous historian and author with the same name, Stephen E. Ambrose. Well, I'm the noise control engineer, the acoustic investigator.
Yes, you're from Maine, correct?
Maine.
Yes.
Right. And I should have been retired, but I've got interested in wind turbine noise and why we're having such a hard time with them when we've been able to noise control noise sources for decades. And I would like to be able to provide unbiased expertise to the board to explain why we're in this difficult situation, because it's the methodology.
Okay, well,
We'll let that, I'll leave it at that.
yes, I want to point out that you're not a party. I don't know if we proceed to testimony, if the McLeans would intend to be presenting you as a witness, for example, as a means to, if we do take testimony, to get your expert opinion on the record. So,
And this is the second one of these meetings I've attended.
in this case?
Not this specific case.
Okay. So I was just saying, my memory's not as good as it used to be if it was in this particular case.
No, that was with another PSB member, Jeff Commons.
Oh, well, Jeff's an attorney at the Department of Public Service, actually. I'm not a PSB member, I'm just a staff attorney. So,
Don't use the word just. Do not devalue yourself. You took a lot of work to become an attorney, so treat yourself with respect.
all right, I appreciate that. Okay, anything else we need to touch base on before we go on the record?
Nothing.
Okay, let's go on the record, please. Good morning, this is a status conference in docket 8613, an investigation pursuant to 30 VSA sections 30 and 209 into sound levels from the Georgia Mountain Community Wind LLC wind electric generation facility in Georgia, Vermont. My name is John Cotter. I've been appointed hearing officer for this proceeding, and with me today in attendance is Andrea McHugh from the board. Let's start out by taking appearances, please.
Aaron Kosicki on behalf of the Department of Public Service.
Stephen Ambrose.
Melanie McLean, and Annette Smith, my consultant.
Okay, just to let the record reflect that it's Mrs. McLean is the party, and she's being accompanied by Mr. Ambrose and Ms. Smith.
Andy Rob Vogel with Dunkill Saunders for petitioner Georgia Mountain Community Wind, and with me is my colleague Sash Lewis.
Okay, thank you. I called this status conference honestly to try and decide where we go from here. There appears to be a pretty significant difference of opinion between Georgia Mountain Community Wind and the Department of Public Service with respect to the modeling that was performed to try and understand the sound levels that were present at the McLean residence on, I believe it was September 18th, 2015. On January 29th of this year, Georgia Mountain Community Wind made a filing that asserted that the exterior sound levels at the McLean residence that night, based on the modeling that it had performed, were below 40 decibels, and they were in the 34 to 36 dBA range. And then the department on May 20th, after conducting a couple rounds of discovery, I understand, made a filing concluded that there was a reasonable possibility that sound levels on September 18th at the McLean residence, to be precise, exterior sound levels, were within 5 dBA of the 45 dBA exterior limit, and recommended that the board order Georgia Mountain Community Wind to perform outdoor to indoor attenuation testing at the McLean residence if the McLeans wanted to have that done. And on June 3rd, 2016, was actually, I should say, that's the date of the filing. It was actually received at the board on June 6th. Georgia Mountain Community Wind responded, contending that the department's recommendation was flawed because the analysis failed to subtract out background sound levels, and that the data that was relied upon in at least some instances was contaminated by periods of rainfall and insect noise. And that was the last thing that I heard. And I guess I'll turn to the department first to see how the department responds to the contentions in the most recent filing from Georgia Mountain.
I think on a very broad level, we would disagree with the contentions that Georgia Mountain Community Wind posits in its response. I think the critical, sort of the crux of the disagreement, I think, centers around what is required of the department in its analysis for making a recommendation as to whether or not attenuation testing at the McLean residence is warranted. Typically, when we look at these issues, we are looking at determining sound levels for purposes of trying to determine CPG compliance. That's not the case here. Under the terms of the complaint protocol contained in the noise monitoring protocol for Georgia Mountain Community Wind, the question of whether or not additional attenuation testing is at a complainant's residence is dictated by the threshold of whether or not there appears to be a reasonable possibility that the project sound level at the time of the complaint was within 5 dBA. That is a very different analysis than trying to determine what the sound levels were absolutely at any given point in time. I think given the complaint protocol that only raises a threshold question of there being a reasonable possibility of a sound level being there, I think it acknowledges that there are going to be difficulties with adequately modeling the sound levels at a moment in time where there's not a particular microphone or set up at the time of the complaint. Because of that, there is no requirement in the complaint protocol that the methodology that is used to determine CPG compliance be used for making a determination as to whether or not there's a reasonable possibility that sound levels were within 5 dB of the limit. As a result, the department's expert that we retained utilized a different methodology, specifically by using amplitude modulation to try to determine whether or not there was a reasonable possibility. We admit that it was a very close call when we conducted the analysis, and even so, we still think that given the analysis that he did is verifiable. It is complete to the best that it can be, given the limitations that the protocol puts on everybody's ability to really determine with specificity what the levels were. And we'd be happy to bring our expert forward to explain the merits of his methodology relative to the question that's been posed.
Okay.
Mr. Cotter, we think you've got to close this investigation at this stage. There's absolutely no basis to continue to try to ascertain whether Georgia Mountain was within 5 dB based upon the information in front of you. And I don't think the department has said anything today or in its filing which would lead to a different conclusion. Georgia Mountain, there is a sound monitoring protocol that directs how it's to be determined whether you're within 5 dB. It's the extrapolation methodology. the question of whether there's a reasonable possibility of whether you're within 5 dB is not an independent exercise. It is strictly tied to the extrapolation methodology. This has been our point all along. In this instance, we have actual first-year data from this residence. There is no extrapolation needed to determine that whether you're within 5 dB. And we reported to the board right from the get-go that there were no aberrational operating conditions that would suggest that the first-year monitoring data can't be relied on. You then directed Georgia Mountain to do something which was not otherwise required in the monitoring plan, to basically look for days from the first-year monitoring that were comparable in terms of weather and power production, and find dates that were comparable to the date in question, September 18th. We did that. And what we found was, given the comparable dates, the sound levels were below more than 5 dB different. The department, in its analysis, did not follow the sound monitoring protocol by any measure. Not only did they, as we pointed out, not subtract out background, but they used contaminated data. And after reviewing 2,328 hours of data, they gave you 1 hour with 29 minutes of contaminated data, which they say was at 40. That is not reasonable. That is not a reasonable basis, and which did not subtract out background. By any measure, that is not a reasonable basis for you to conclude that we were within 5 dB. And for that reason, we see no point here other than to simply close the investigation.
So, Mr. Kosicki, just so I understand, or actually, excuse me, before I come back to you, I want to ask Mr. Rob Vogel something. Let me go to Aaron
Can I,
first.
before you turn to Mr. Kosicki, I do want to make one additional point. You started this status conference by stating that there seems to be sort of a fundamental disagreement. I actually don't think there is a fundamental disagreement. As I just reflected, there's 1 hour that the department has focused on. But what the department said about Georgia Mountain's analysis was, after reviewing extensive data collected in 2 rounds of discovery, the department concluded RSG's data and analysis used in the modeling report was accurate and the conclusions were sound. I think you need to think about that rather than the 1 hour of non-reliable data that they're focusing on.
Okay. So, Mr. Kosicki, I don't know if you can explain this to me in a way that I can fully comprehend today, because this is technical data. I'm an attorney that was a journalism major in college, so. Is Mr. Rob Vogel accurately characterizing the work done by the department's consultants in saying that background sound levels were not subtracted out from the overall sound level?
As an attorney myself, who is a political science major, I will try to explain the best I can, with making very clear that I am not a sound expert. My expert is not here. My understanding of the analysis that was conducted by our expert, the answer would be no. That characterization is not true, and this is a nuanced answer. I think Mr. Rob Vogel is correct in stating that a significant portion of the data that the department's expert analyzed for making this determination did contain background contamination. That is the reason why, in large part, and I think this sort of gets to one of the fundamental problems with using the methodologies that are contained in the protocol for determining CPG compliance, which versus what's being asked here to try to justify, determine whether or not attenuation testing of the McLean residence is justified. That is, when you have a 1 hour LEQ averaging time frame, there's going to be necessarily, by virtue of how turbines operate, meaning the driver of turbine noise is also the driver of background noise typically around these projects, i.e. wind. Because we didn't have microphones around the area at the time, the complaint was being made. The department sought to try to identify a broader range, scope of conditions that had been monitored during the first year quarterly monitoring protocol. Mr. Grubvogel is correct when he says that we agree that RSG's analysis of that was contained in their initial report is accurate. However, we felt that there was also additional time periods that were worth taking a look at. And in one of those, our expert used an alternative methodology, amplitude modulation, which in its application is there to identify when there is adequate project-only noise and there is devoid of significant contamination to the point where there is a high degree of confidence that the levels that are being experienced at that time are free of contamination. And those were the time periods that our expert used to make the determination that there was a likely possibility, or I should say, a reasonable possibility that there were sound levels that night within 5 dB.
What about the Georgia Mountain's contention that the 1 hour period, I think it was from the month of June of 2013, if I'm remembering correctly, June 17th is jumping to mind, that there was 29 minutes of rain during that period. Does that strike the department as significant amount of contamination or not?
I mean, I can't speak to what constitutes a significant amount of contamination and what doesn't. I want to be able to answer your question fully, and I don't think I can, given my lack of expertise.
That's fair.
I'm more than happy to, like I said, I'm more than happy to answer any questions, bring any questions you might have to our expert, who can certainly answer those in a much more technically proficient manner than I can.
Mr. Cotter?
Yes.
Could Steve Ambrose expand on that for you?
We're not here to take evidence today.
Can I consult with him then and I can speak?
May I?
Yes, Mr. Ambrose.
I would like to give Mr. Kaliski? Kisicki, I'm sorry, I gotta get. I have two charts here that may end up explaining the difference between modeled and measured, and it was done by RSG.
Mr. Kusicki, I need to object.
Everybody's getting called by the wrong name.
Sorry, Mr. Cotter. For the reasons that you started, there's simply no reason or no basis to take any information directly from Mr. Ambrose that goes to the evidence or the facts in this case.
How about if I
That's it.
give it Lynn?
Right, I think what the issue here is that if you want to work offline with the department and consult with the department, if the department is willing to do so, you're certainly free to do so. And what we're trying to find out today is what the next steps should be in this proceeding. And after I take everything I hear today under advisement, if I decide that the next step is I need more information, then at that time, certainly, if you were to use Mr. Ambrose as an expert, you could submit information from him, just as the department submits information from its experts and Georgia Mountain submits information from its experts. But that's not what we're here to do today. This is just a status conference. So,
Well, I was just curious about the 5 dB discrepancy, because RSG pointed out why that 5 dB exists in a previous peer-reviewed report.
okay, that's fine. I would encourage you to talk to the department
Okay?
outside of the hearing room today.
Fine.
And maybe if we're back
On your departure, I will hand you a piece of paper.
in the future, if we're back in here and taking evidence and pre-filed testimony, witnesses are on the stand, then that'll be the
No,
appropriate time for that.
it's an important issue that's being dealt with right here, and misunderstanding does not provide benefit for anyone.
Yes, I appreciate that fact. It's that we're not here today to drill all the way down into
Right.
that. Okay, thanks. Yes, Mr. Rocco.
2 points. Firstly, we filed, the department filed its recommendations in May. We filed a response in June. The McLeans had ample opportunity to make any reply then, and I don't think it makes sense today to start trying to backfill a reply. Let me just start there. Secondly, I would urge you, when you go back and deliberate on this, not to simply err on the side of more process, because I don't think in this case it's justified. I think a hard decision has to be made by you. I understand that you are in the difficult spot of having to decide on what appears to be a disagreement between the department and the CPG holder. But I also think what should weigh here is the weight of the information we've provided, the background of the noise monitoring plan, and the substantial resources of the board, the department, and the parties that have already gone into this investigation, and that will go into it further if you simply order more discovery, more testimony, more process. I don't think that's simply the answer, and it will be unduly expensive for reasons that are not appropriate under these circumstances. So I would simply ask you to consider that.
Okay. Now that I've asked Aaron Kasinke a few questions, Mr. Rallo, I do want to come back to you. I understand it's your client's position that the department's consultants did not appropriately isolate the project sounds from the background sounds. And it also seems to be your position, if I understand what you've been saying today, that really the only way to do that, whether we're talking about CPG compliance with the 45 limit, or whether we're talking about are we within the 5 dBA range that would justify attenuation testing, that the only way to do it is to follow the specific protocol that is set forth in the sound monitoring part of the plan. Is that correct?
It is, and the point that we made to you before you issued your initial ruling was that there was really no basis to require us to do that modeling, this comparison to the original first-year data, that under the sound monitoring plan, it says if you have data at a particular location that shows that you're within compliance, that there's not a basis within 5 years to even require more testing. So we thought right at the outset that there was simply no basis to even go down this road, that the monitoring plan actually spoke to this precise situation. There was actual data done the first year at the McLean residence. It consistently showed under 40, there was more than 5 dB difference between the noise limit and the 1 hour LEQ at that residence. And there was simply no basis, short of there being a demonstration that the operating conditions were aberrational, of which there has been none. And we have represented that the operating conditions were normal. There was no basis to even begin the investigation. So in that sense, we think the monitoring plan speaks directly to the circumstances here, and one can conclude on that basis alone that there's no basis to do further testing.
So, if I understand you then, is it your client's position that absent aberrational circumstances in operation, the board really should not entertain any complaints because during the first year of monitoring, if the project was in compliance?
I think that for the somewhat limited circumstances where you have actual data at a particular residence, which is not going to be very often, that is, there were only a limited number of monitoring sites for the first year. But in those limited set of circumstances, we do think that absent aberrational conditions, the intent of the monitoring plan, which was reviewed and commented on by parties to the extent they have the desire to, and approved by the board, was that there was, yes, you would provide a degree of certainty and you could rely on the existence of that data, not to simply retest and require additional process at a place where you had actual data. There's going to be a lot of residences where there isn't actual data unless there's site-specific testing, and that would be a different situation.
Okay, I want to reach back to something you just said a moment ago and just test that. You said that during the 2013 monitoring that was performed at the McLean residence, the difference between the monitored sound and the exterior limit of 45 was always greater than 5 decibels. The department in its October filing said that there were a number of times where the sound level monitored at the McLean residence reached 40 dBA. And in a letter that you filed on November 2nd, 2015, you have a footnote number 1 on page 2, which is apparently quoting the sound monitoring report that was filed. And it says, when all gusty wind and rain periods are removed and background sound levels are subtracted according to the protocol, the highest sound level recorded at the McLean residence is 40 dBA. That was filed by you.
Yes.
So do we actually have at least one period, if not more according to the department, where we were actually within 5 dBA of the exterior limit at the McLean residence using actual data?
Can I just go back and look at that filing
Yeah,
for a moment?
sure.
And you said November 2nd?
Yes, your letter was dated November 2nd. That's correct. And it was your initial response, I think, to the McLean's complaint.
I have it November, excuse me for a moment. Sorry, give us a moment.
Oh, sure, no problem. Oh, you know, I'm sorry, Mr. Rambo, it's your response to the department's comments dated November 2nd.
Yes, we found it.
Okay.
Give us another moment, please. Yeah, sorry, I stand corrected. Let me correct 2 things. One is, you're correct that we reported that it was no higher than 40, so that 40 is 5 dB difference from 45. The sound monitoring plan, I believe, says if there are no exceedances, if you've done site-specific testing within 5 years, I don't believe you have to retest that location if you determined compliance previously. In other words, we've already demonstrated, compliance with the CPG condition. And so we think there's no basis to require additional testing or even going through the extrapolation methodology in a
Right.
case like that. And we don't think the monitoring plan contemplated, part of this, I think, is that the monitoring plan didn't ever expect that you would have the first year done at a residence, have that data, and then you can't really apply the extrapolation 5 dB portion of the plan because it has no applicability to that situation.
Right, I think you're getting ahead of where I was going on this. So are we in agreement that there was at least one occasion when the project only sound levels were within 5 dBA of the 45 dBA exterior limit at the time the sound monitoring was being performed?
Yes.
And did your client at that time offer to the McLeans to perform outdoor to indoor attenuation testing as is required by the protocol?
We did not.
That's my assumption because your November 2nd letter asserted that you were not, your client was not required to offer it, that the McLeans would have had to have requested it. you did subsequently correct that in another letter.
But I think you're tying two things in the plan that are not tied, which is, we did first-year monitoring at that actual residence that showed CPG compliance. The part of the protocol that discusses offering indoor-outdoor testing is, part of it is the complaint protocol that relates to the extrapolation methodology and whether you're within 5 dB. That whole portion of the monitoring plan has nothing to do with whether you've demonstrated in the first year that in fact you comply with the CPG conditions.
No, I understand. I'm not having a discussion with you about whether or not compliance with the 45 dBA exterior limit was demonstrated by the monitoring or not.
Right.
I'm taking that as a given. That's what the report shows. But what I'm asking you
Yeah.
is, why didn't your client offer to perform attenuation testing in response to the 40 decibel reading at the McLean
Yes.
residence? And my understanding is the McLeans have been complaining to Georgia Mountain pretty much since the project went online.
We viewed that once that data was presented and it was shown that the project was in compliance, that there was not a continuing obligation to offer indoor-outdoor testing at the McLean residence.
Right, again, I'm not talking about compliance with the 45 dBA, but explain to me why there was not an obligation to make that offer when that information became known to your client.
That's the part that I'm having trouble with. It's not simply when that information became known to my client that there was an obligation. Our obligation was to go through the complaint monitoring protocol. Excuse me for a second, I'm just looking at the protocol.
Sure.
Mr. Cotter, rather than wasting your time having us look at this, I'd be happy to respond in writing on
Okay.
your question, whether, I won't restate your question, I think I understand it.
Yeah. Mrs. McLean, I don't want you to feel left out.
Well, I'm gonna go back to the first year of monitoring and ask what percentage of that monitoring period the wind turbines were at full capacity, full power output. I think it was like 1% of, it's a very, very small number. So I'm not surprised that they don't have a date that they can't compare to the noise of September 18th or whatever it is.
Right, my understanding, however, is that the turbines reach their full sound power level before they reach their full output level. So,
Really?
And
Can I?
you can consult with me, yes.
No,
No,
not in, only on test stands, but not on mountaintops,
because
ridge
that,
lines.
yeah, that's not what we'd experience as, neighbors. We
Okay.
certainly can tell when they're working at full capacity just by the number of rotations. And boy, we can tell you that's when they're the loudest.
Okay, that's fine. Department, input to the discussion I was just having with Mr. Roglow?
No, I just think we're really just distilling the disagreement or difference that the department has with Georgia Mountain, which is, and I think you've sort of hit the nail on the head, which is, in our October filing, we noted that we saw that there was instances that were within 5 decibels. I think that that militates towards, offering testing here. But I think in the final analysis, I just want to make clear that while it was, and I will stress this again, it is a close call. This is 40, a little bit over 40 decibels that we saw, and we saw that it was not only possible, but we think that that possibility is reasonable, and that's what's required under the complaint protocol, and that's what we acted on, and that's why we're making the recommendation that we are today.
Okay. I think that probably I am going to need some material in writing in order to really distill this. Obviously, this is just a status conference, and so there's only so much we can accomplish today. So I think what I would like to see from the department is a better explanation, preferably that I can understand, of what steps your consultants undertook, and an explanation of why the sound levels that were reported by the department in its recommendations are actually project-only sound levels, that background sound has been accounted for, as well as the question raised regarding the use of contaminated data. In particular, I'm curious about the 29 minutes of rain for the 1 hour period that was reported. Mr. Alvogel, would your client want an opportunity to respond to what the department files?
If it's with your permission, yes.
Sure. Okay. And we'll talk about dates in a minute. And then, Mr. Alvogel, you said you wanted to provide something in writing regarding GMCW's obligations with respect to offering attenuation testing back in 2013 when the 40 decibel levels were reported at the complaint house.
Yes.
Okay. And then, Mr. Kosicki, would you want an opportunity to respond to that?
I don't think that will be necessary.
Okay.
But
So
since,
it's your call.
I was going to say, since you've asked, I'd like to reserve a date. We don't have to use it, obviously, but.
All right, we can do that. So, well, let's talk dates. Oh, Mrs. McLean, I'm sorry. It's kind of like it's been kind of like a tennis match up
No, I
here.
understand it, but I also am sitting here thinking it's next month will be a year since our complaint, and you're still not sleeping. And I just want you to consider that when you think about all this.
I understand, but this proceeding is not going to result in the board closing the Georgia Mountain facility.
That's not what I'm asking.
I can tell you
Don't-
that.
That's a ridiculous
Yeah.
assumption on your
Yeah.
part. to
No,
think that
I
would
just
ask that.
I just want you to
No.
understand that. And what this hearing is about is, the first question is whether or not the company should be required to do the attenuation testing in
Exactly.
your residence.
Exactly.
And
That's
secondarily,
right.
was there actually a violation there? And if there was a violation, then what sort of penalty would be
I
appropriate?
understand. What I'm
Okay.
asking for is the things to be speeded up a little bit,
Okay.
so that maybe we can get some resolution before I die.
I should point out that there was some delay in getting the status conference scheduled, and that delay was driven in part because the department had concerns about if there was attenuation testing to be done, the actual process and details for doing it. And that same question had arisen in another docket, and I didn't want to end up doing things inconsistently and at odds with other hearing officer recommendations and what would ultimately, I assume, be a board requirement. So that's why I waited to schedule the status conference. There was actually a reason for it. And my understanding is in the other docket, the hearing officer has issued an order setting forth what he believes are the appropriate protocols for doing the attenuation testing. So I have to kind of see where that ends up if we do end up directing attenuation testing in this docket. So just want both dockets to be on the same page, and we want to get it right. So,
Thank you.
do you, I would think that you might wanna file something in response to what these folks may file, and knowing that we have two different filings coming in.
Mhm.
Okay, so, we'll just have the response date be applicable to you, and as they discuss dates and response dates, keep your ears open and make sure that, that a date doesn't get set that doesn't work for you, okay? So, Mr. Kosicki, do you have a date to propose for the department's filing?
It sounds like we only have 3 dates to nail down. Our filing, your response, and then potentially our response. And I would assume if you feel like responding to.
Sorry, say that,
It would be-
we each have a filing to make,
We
which
each
could
have
be
a
on,
filing.
which could be on the same day, presumably. And then we
Whichever
each,
you'd like.
then we each get to reply, just,
Right,
I think
okay.
that way we're dealing with fewer
Right,
dates.
and so,
And the McLean's
Right.
would respond to both.
so here's my issue, is that I need to be able to get in contact with my expert. I'm not quite sure what his availability is right now. But there's a complicating factor on my end, which is I'm out from the 19th, and I don't come back until the 29th, which sort of, it may be that my expert can get something, can turn around a response in very short order. It might not be. So it might be worth just discussing as soon as I get in touch with my expert, try to fashion a schedule and submit it to Mr. Carter.
I would be fine if you want to try to come up with suggested dates
Is that,
that the McLean's can live with as well.
okay?
That's fine by me, if,
Yeah.
you know, just as soon as you've reached dates that are agreeable to everyone, including Mr. and Mrs. McLean, so
And
make sure.
Mr. Ambrose?
That's right, well, that will be part of your job, will be making sure that whatever date you as the party ultimately agree to works for Mr. Ambrose. So, and then just as soon as folks reach agreement on that, then somebody can make a single filing and just represent that everybody agrees to it, and I'll be fine with that, and then I'll get a scheduling order out. In the event the parties are unable to agree on dates, which I'm hopeful will not be the case, then you just need to inform me of that. I'll pick some dates. So to be clear, what I'm looking for is a schedule in which Mr. Rob Vogel's client will be filing a written analysis of whether or not he believes attenuation testing should have been offered during 2013 based on the 40 decibel levels recorded at the McLean household. Looking for a filing from the department clarifying its position with respect to the modeled sound levels that it reported to the board, including an explanation of whether or not and how background sounds were taken out of the report so that turbine-only sounds were isolated and reported, as well as an explanation of the effects of any contaminated data. And then a response date should be selected so that all of the parties can respond to those two filings, including Mrs. McLean.
And will there be a status conference memorandum articulating those questions issued shortly, or just so we know what to expect?
Yes, I'll do that as soon as possible.
Thank you.
Okay, does everybody understand next steps? Anything else we need to discuss? All right, I appreciate everybody's time today. Thanks very much. Roger.